Welcome to week one review for legal environment. I hope you've had a good week. So just to kind of summarize what we went over, grading in this class, there will be 4 tests. The tests are 70% of your final grade. The final exam is 30%. Watch out for quizzes. So we may, from time to time, have quizzes as I review for the test, and they may add up to 5 points to a test grade. And then finally, you have the opportunity to do extra credit by visiting the historic Moat Museum here in Farmville with a short executive summary of what lessons that you've learned. I will add 5 points to your test grade. So let's begin. Here's what you learned this week. So what is law? So law establishes minimum standards by which we are to conduct ourselves. And our system of laws in the United States is based on the English common law, that is case law that developed over time. Some of these cases date back to the 12th century. The purpose of law is to provide order and stability and justice. You learned that there were 4 major sources of law in the United States. We have the U.S. Constitution. Actually, we also have a state constitution. But the U.S. Constitution, statutory body of law, case law, and administrative regulations. All right, so what about the Constitution? Our Constitution is the supreme law of the land. It created our structure of government and the relationship of the government to the people. Actually, it's a brilliant document. With only 4,440 words, it accomplished quite a lot. It created our federal system of government. That is, power is shared between the federal government and the states, which is one reason that we have 2 court systems. We have the federal court system and the state court system. And I will summarize these in just a minute. You also learned that there are 3 branches of government, and they are the legislative branch, the executive branch, and the judicial branch. The purpose of the judicial branch is to interpret law. Individual rights. So under the Constitution, any power that's not specifically granted to the federal government is considered to be a reserved power to the states. To date, there have only been 27 amendments to our Constitution, so that's relatively few. Our Bill of Rights is the first 10 amendments to the Constitution, and we spend a lot of time talking about the First Amendment. The First Amendment is the First Amendment for a good reason. It is the most important amendment. So you should know the 5 rights guaranteed by our First Amendment to the Constitution. Freedom of religion, freedom of speech, freedom of the press, the right to peacefully assemble, and the right to petition the government for a redress of your grievances. All right, so the second major source of our law is statutes, our statutory body of law. All right, so far you've learned the Constitution, statutory body of law. The statutory body of law includes bills that are passed by Congress. Actually, all laws passed by legislative bodies, so including your local or town ordinances. So bills passed by Congress, laws passed by state legislatures, county and town ordinances, these are all considered to be part of our statutory body of law. All right, so what if there's a conflict between a federal law and a state law? We have this doctrine called federal supremacy. So if there is a conflict between a state and a federal law, the federal law governs. In other words, the federal law is supreme. Oh, I went a little bit too fast there, so let me back up. Administrative agencies. You also learned that part of our body of law includes administrative regulations. There are hundreds of administrative agencies if you count state administrative agencies and federal administrative agencies. Administrative agencies are not elected bodies, and they have a lot of power. So administrative agency combines legislative, executive, and judicial powers. Their regulatory powers are quite broad, and these powers were expanded in the 1930s with a famous case known as Wickard versus Filburn, and this was also known as the New Deal wheat case. This is a farmer. Old Roscoe wanted to grow some extra wheat so he could feed his livestock, not livestock for sale in interstate commerce, but for his family's consumption. And he exceeded the amount that he was allowed to grow under an administrative regulation and was fined. And he said, "You can't fine me because I'm just growing wheat for my own consumption, for my family's consumption." And the court in this case held that interstate commerce would include old Roscoe growing wheat for his family. So in other words, this case broadened the regulatory powers of an administrative agent. See, they're incredibly broad. You also learned about the exhaustion doctrine, and I told you a story about my husband and I are probably the only people you'll ever meet who have sued the federal government. We sued Health and Human Services and won. So here's what you need to know about the exhaustion doctrine. In a dispute with an administrative agency, you must first exhaust your administrative remedies before being able to appeal to what I consider to be a real court. So if you're before a federal administrative agency and that administrative agency has a court system, you have to go through their court system first before you're allowed to appeal to a federal court. If it's a state administrative agency, you have to go through their court system first before you're allowed to appeal to a state court. By the way, there is no right to a jury trial before an administrative agency. All right, so another source of law is case law. So remember that our system of laws is based on the English common law. In fact, the legal system in all 50 states is based on the English common law with the exception of, you got it, Louisiana. And Louisiana's law is based on the Napoleonic Code or French civil law. Our earliest cases, as I said earlier, date back to the 12th century. And a court decision may become precedent to be followed in the future. And the rule that a case becomes precedent is known as the doctrine of stare decisis, or to stand by the decision. Other sources of law, and these are very important sources of law, uniform state laws. So we have the Uniform Commercial Code, and if you're in business or if you're buying something or selling something, you need to know what the law is going to be governing that transaction. So all 50 states have adopted the Uniform Commercial Code and the identical Uniform Commercial Code, with the exception of Louisiana. Theirs is slightly different. So that's one source of law that we will cover in this course. An executive order is also a source of law. The president or governor may issue an executive order, and I gave you this executive order that was issued by Governor Northam on May 26th. Masks must be worn in public indoor spaces. And then finally, a treaty is also a source of law, although it's not one of the four major sources of law that I named. A treaty is an agreement among or between two or more countries, and a treaty sponsored by an international organization is simply known as a convention. Here's some terms for you to know. A jurisdiction is simply the power of a court to decide a matter. In a civil case, the person who's suing is called a plaintiff, and the person who's being sued is the defendant. And of course, arbitration is simply an out-of-court method of resolving a dispute. Advantages of arbitration include it could be faster, less expensive, and you may hire an expert to be the arbitrator. Here are the Virginia courts. This is the Virginia court system. We learned a little bit about the Virginia court system. The General District Court is our entry-level court, and that's our version of small claims court. This is a court of limited jurisdiction. You may very well end up in General District Court representing yourself. Our only court of general jurisdiction in Virginia is the Circuit Court. The Circuit Court hears criminal matters. It also hears civil matters. It hears appeals from the General District Court. And from the Circuit Court, you may appeal to the Court of Appeals. The Court of Appeals probably is as far as you'll get to go if you are involved in a dispute. You'll see, though, that there's a line going directly from the Circuit Court to the Supreme Court of Virginia, and if indeed you have a dispute involving the State Corporation Commission, or you've received the death penalty, or In an instance where an attorney has been disbarred, there's an automatic right to appeal to the Supreme Court of Virginia, although other than these three exceptions, appeal to the Supreme Court of Virginia is discretionary. And then we looked a little bit at federal courts and jurisdiction of federal courts. And you may have an instance where you could be in state court, or perhaps you could bring your case in federal court. And in order to be in federal court, you must have a federal question presented. So in other words, is there a dispute involving a constitutional issue? Or do you need to resolve a dispute about a U.S. statute or a U.S. treaty? If you do, then perhaps you could be in federal court. If you're suing the federal government, or if you are being sued by the federal government, you could be in federal court. And then finally, and I always ask this on the first test, if there is diversity of citizenship. In other words, if you have a plaintiff from one state and a defendant from another state, and at least $75,000 in controversy, you may be in federal court. All right, so after I introduced you to the legal system and to our court system, we began our discussion of contracts. And this is these are some of the terms that I wanted you to know. So an offer simply expresses a willingness to enter into a contract. Remember, you don't have to have any magic legal words to constitute an offer. An acceptance simply mirrors an offer. So an acceptance may not add additional terms to the offer. If it does, then it's considered to be a counteroffer, and a counteroffer would revoke an offer. So the three basic elements of a contract are offer, acceptance, and consideration. Consideration is merely the price paid for a promise. It could be money, it could be services, it could be giving up a right to do something. It could even be goods. I like to think of consideration this way. It is the element that distinguishes an offer to make a gift, which is not a binding legal obligation, from a binding contract. So I offer to sell you my watch for $10. You say, I accept, I will bring $10 to you tomorrow. $10 is the consideration, the price paid for my promise to convey my watch to you. You must also have competent parties, and we'll spend about a half a day talking about mental competency. And any contract made by a minor, that is someone who has not yet turned 18, is voidable at the election of the minor. Contracts must have a lawful objective. Illegal contracts are unenforceable, and again, we'll spend about a half a day talking about that. And then a contract must be evidenced by a proper form. In other words, certain contracts, not all, have to be signed and have to be in writing. And we'll talk about the statute of frauds. Types of contracts. Remember, a contract will either be an express contract or an implied contract. An express contract is one that's simply entered into through language, either written or oral. An implied contract, on the other hand, is one that's implied or deduced from the conduct of the parties, for example, going to the doctor. A contract will either be formal or informal. Most contracts, by the way, are informal contracts. But a formal contract is enforced not because there's offer acceptance consideration, but because of the formality with which it was executed is sufficient to show the world that you really intended to enter into a contract. And then a contract will either be bilateral or unilateral. Most contracts are bilateral contracts. In other words, a promise is exchanged for another promise. So the example I used in class, I offer to sell you my watch for $10 and you accept. That's a bilateral contract. A unilateral contract is accepted by performing an act, such as a reward case. So I've lost my dog, I post a reward, $100, anyone who returns my dog to me. How do you accept my offer? By returning my dog. We'll talk more about unilateral contracts in this class too. And then contract terms for you to be familiar with. Executory simply means the contract has not been fully performed by both of the parties. Executed means The contract has been fully performed. A void contract is one without legal effect, and a voidable contract, such as one made by a minor, may be voided at the option of one of the parties. And then finally, we learned about quasi-contract. And quasi-contract is a legal fiction. It's not a real contract. And this doctrine may be applied to avoid unjust enrichment. And this was the house painter example I gave you. And real quickly, I'll recap that. So let's say my neighbor enters into a contract to have her house painted while she's away on vacation. It's the summertime. She doesn't like the way paint smells. And the painter's going to paint her house for $2,000. He's going to come in a month to paint it. A month later, he shows up at my house by mistake. I'm at home. I'm off for the summer. I see the house painter there. I hear him. I don't stop him. He paints the entire outside of my house. The following Monday, he knocks on my door with a bill for $2,000 and hands it to me. Do I have to pay it? And the answer is yes. Under the doctrine of quasi-contract, I would be unjustly enriched if I didn't have to pay him for his services because I knew he was painting my house and I did not stop him. All right, so I hope you have had a good week, and I will see you next week. Thank you.